trusts are much harder to challenge than wills. Why is that? Let me tell you. Well, there's a couple of reasons. One is that oftentimes wills are done hasty at the last minute. Someone gets diagnosed with some terrible illness, they're afraid they're going to die, and they jump on the internet and download a will form and fill in the blanks, or they steal one from a family member and fill in the blanks, or go to Office Depot or Staples and, well, you guess it, buy the will kit and fill in the blanks. Trusts, on the other hand, are more robust. They're drafted by attorneys typically, and the attorney has a thought process and a system to limit the effectiveness of a contest to the estate plan or somebody objecting to it. So that's the first thing, is they're done by attorneys, and usually there is better thought process. For instance, the attorney will interview the client for capacity. That's the number one challenge. Is mom and dad had dementia. They didn't know what the hell they were doing. They never would have cut me out because I'm their favorite son. Well, the attorney can say, no, I interviewed your parents, and they explained to me all the things that you've done to them and the way you've treated them, why you're basically a piece of crap, and that's why you are out of the trust. They certainly knew what they were doing, Judge, and that usually goes a long way. Another thing, speaking of Judge, is that if you go through probate, which your last will and testament is your roadmap through the probate process, there's already a judge assigned to the case, and your degenerate child could write a jailhouse letter to the judge saying, Judge, this isn't fair. I don't like what happened. My parents forgot about me, or they were influenced by someone else in the family. The judge will put the probate on hold. They will call a hearing. They will want evidence, and it will drag out the process. But the point is, the degenerate gets their day in court with the judge for free. Trust, on the other hand, doesn't have a judge involved. So if your degenerate child wants to challenge your trust, they have to go out and spend money out of pocket, which they probably don't have, because most people that get cut out of trust don't have two nickels to rub together anyway. They have to spend money and time, paying thousands of dollars to an attorney to challenge the estate plan and file a formal lawsuit, go through discovery, and all the things that we all hate about litigation. So for those reasons alone, a trust is better than the will when it comes to the contestability. And there's a million other reasons trusts are better. Watch my other videos. I don't have time for that here. But think about it. If you think that one of your family members is going to bitch and moan when you're gone and try to challenge things, you want to do it in a trust and not a will. Makes it more difficult and less likely that they will be successful in challenging your wishes after you die. Have a great day.